Good day, everyone. We are the Group 5, and we are here to discuss about the Judicial Department. So, the 1987 Constitution of the Republic of the Philippines, Article 8, discussed or states about the Judicial Department. So, what is Judicial Department? This is the third branch of government, which is it is the system of courts that interprets and applies the law in the name of the state. The judiciary is made up of courts supreme, circuit, the magistrate or local, and municipal city courts. The judicial branch interprets the laws. So the judiciary of the Philippines consists of the Supreme Court, which is established in the Constitution, and three levels of lower courts, which are established through law by the Congress of the Philippines. The Supreme Court has expansive powers, able to overrule political and administrative decisions, and with the ability to craft rules and law without precedent. It further determines the rules of procedure for lower courts, and its members sit on electoral tribunals. Okay. Below the Supreme Court is the Court of Appeals, which also has national scope with different divisions based on different regions of the country. Decisions from this court can only be appealed to the Supreme Court. Below this level are regional trial courts, which are spread throughout the country among judicial regions. Some of these courts are specialized to deal with certain types of cases. Below these courts are the first level metropolitan and municipal trial courts, which are located in cities and municipalities throughout the country. Next, we have the section 1 for the judicial under Article 8. So, in section 1, it states that the judicial power shall be vested in one Supreme Court in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Next, section 2. So it states here that the Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts, but may not deprive the Supreme Court. So here, the Congress has given the authority or the power to define or prescribe, but to but may not deprive or take away the Supreme Court of its jurisdiction or the right of the Supreme Court power or authority to administer justice by hearing and determining controversies and to interpret and apply the law. So Congress, they enact laws that influence the daily lives and of all and intended to serve as the voice of the people. Congress is responsible for making enabling laws to make sure the spirit of Constitution is upheld in the country and at times amend or change the Constitution itself. Here, no law shall be passed reorganizing the judiciary when it undermines the security, when it threatens the members of of the Constitution. So here in section 2, it is clear about the rule of the Congress and the rule of the Supreme Court. So the judiciary plays a fundamental role in society and for the upholding of social order. So its primary function, in fact, is to resolve conflicts through the application of pre-existing norms. Section 3. The judiciary shall enjoy fiscal autonomy. Appropriations for the judiciary may not be reduced by the legislature below the amount appropriated for the previous year, and after approval shall be automatically and regularly released. So Section 3, it stated that the funds for the operations of the judiciary may be increased but not reduced. It should not be lower than the amount appropriated in the preceding year. Once approved into law, the appropriation shall be automatically and regularly released without the Supreme Court having the request the President or budget officials. Section 4. The Supreme Court shall be composed of a Chief Justice and 14 Associate Justices. 8 may sit in bank or in its discretion in division of 3, 5, or 7 members. Any vacancy shall be filled within 90 days from the occurrence thereof. All cases involving the constitutionality of a treaty, international or executive agreement, or law, which shall be heard by the Supreme Court in bank, and all other cases which under the rules of court are required to be heard in bank, including those involving the constitutionality, applications or operations of presidential decrees, proclamations, orders, instructions, ordinances, and other regulations shall be decided with the concurrence of a majority of the members who actually took part in the deliberations on the issues in the case and voted thereon. Cases or matters heard by a division shall be decided or resolved with the concurrence of a majority of the members who actually took part in the deliberations on the issues in the case and voted thereon, and in no case without the concurrence of at least 3 of such members. When the required number is not obtained, the case shall be decided in bank, provided that no doctrine or principle of law laid down by the court in a decision rendered in bank or in division may be modified or reversed except by the court sitting in bank. So Section 4, it's all about the prime duty of the government is to serve and protect the people. The government may call upon the people to defend the state, and in the fulfillment thereof, all citizens may be required under conditions provided by law to render personal militarity or civil service.
Section 5. The Supreme Court shall have the following powers: exercise original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibitions, mandamus, quo rento, and habeas corpus. Review, revise, reverse, modify, or affirm on appeal or certiorari as the law or the role of court may provide final judgment and order of lower courts in a all causes in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. B. All cases involve the legality of any tax imposed, assessment, or toll, or any penalty imposed in relation thereto. C. All causes in which the jurisdiction of any lower court is in issue. D. All criminal cases in which the penalty imposed is reclusion perpetua or higher. E. All cases in which only an error or questions of law is involved. Assign temporarily judge or law court to other stations as public interest may require. Such temporary assignment shall not exceed 6 months without the consent of judge concerned. Order a change of venue or place of trial to avoid a miscarriage of justice. formulate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, that the admission to the practice of law, the integrate bar, and legal assistance to the underplayed. Such rules shall provide and simplified and expensive procedure for the speedy disposition of cases. Shall be uniform for all courts to the same grade and shall not diminish, increase, or modify substantive right. Rules of procedure of special courts and quasi-judicial bodies shall remain effect unless disapproved by the Supreme Court. Appoint all official and employees of the judiciary in accordance with the Civil Service Law. And Section 6, the Supreme Court shall have administrative supervision over all courts and personnel care of.
Section 7. No person shall be appointed member of the Supreme Court or any lower collegiate court unless he is natural born citizen of the Philippines. A member of the Supreme Court must be at least 40 years of age and must have been for 15 years or more a judge of lower court or engaged in the practice of law in the Philippines. The Congress shall prescribe the qualifications of judges of lower courts, but no person may be appointed judge thereof unless he is citizen of the Philippines and a member of the Philippine Bar. A member of the judiciary must be a person of proven competence, integrity, probity, and independence. Section 8. A judicial and a bar council is hereby created under the supervision of the Supreme Court, composed of the Chief Justice as ex officio chairman, the Secretary of Justice, and a representative of the Congress as ex officio member, a representative of the integrated bar, a professor of law, a retired member of Supreme Court, and a representative of the private sector. The regular member of council shall be appointed by the President for a term of 4 years with the consent of the Commission on Appointments. Of the members first appointed, the representative of the integrated bar shall serve for 4 years, the professor of law for 3 years, the retired justice for 2 years, and the representative of the private sector for 1 year. The clerk of the Supreme Court shall be the secretary ex officio of the council and shall keep a record of its proceedings. Then the regular member of the council shall receive such emoluments as may be determined by the Supreme Court. The Supreme Court shall provide in its annual budget the appropriations for the council. The council shall have the principal function of recommending appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign to it.
The members of the Supreme Court and the judges of the lower courts shall be appointed by the President from at least 3 nominees prepared by the Judicial and Bar Council for every vacancies. Such appointments no need confirmation. For the lower courts, the President shall issue the appointments within 90 days from the submission of the list. In Section 9, stated that the members of the Supreme Court and the judges, the President will be the one who is responsible to give their possession for at least 3 nominees for each possession, which is possible for the elected to sit in the position, while in the lower court, only small courts, they can report to duty within 90 days from the submission of at least of nominees. So in Section 10, the salary of the Chief Justice and the Associate Justice of the Supreme Court and the judges of lower courts shall be fixed by the law. During their continuance in office, their salary shall not be decreased. In Section 10, the salary of the Chief Justice and the Associate Justice will be immediately judged according to the law if they continue in service, and there is no changes in their salary.
Section 11. The members of the Supreme Court and judges of lower courts shall do hold office during good behavior until they reach the age of 70 years or become incapacitated to discharge the duties of their office. The Supreme Court and bank shall have the power to discipline judges of lower courts or order their dismissal by a vote of a majority of the members who actually took part in the deliberations in the issues in the case and voted thereon. This states that the members of the Supreme Court and the judges of lower courts are required to serve in good standing until they are 70 years old or become unable to perform the function of their positions. By a vote of a majority of the members who actually participated in the discussion of the issues in the case and voted thereon, the Supreme Court and bank has the authority to reprimand or dismiss judges of lower courts. Next is Section 12. The members of the Supreme Court and of other courts established by law shall not be designated to any agency performing quasi-judicial or administrative function. This explains that the members of the Supreme Court and other legally recognized courts may not be appointed to organizations with administrative or quasi-judicial duties.
Section 13. The conclusions of the Supreme Court, in any case submitted to it for decision, embark, or in division, shall be reached in consultation before the case is assigned to a member for writing of the opinion of the court. A certification to its effect signed by the Chief Justice shall be issued, a copy thereof attached to a record of the case and served upon the parties. Any member who took no part or dissented or abstained from a decision or resolution must state a reason thereof. The same requirements shall be observed by all lower collegiate courts. So in Section 13, before they propose and submit the law, the Supreme Court leader shall submit the decision embark before it is assigned to the members to write their opinions about it. Embark means a session in which a case is heard before all the judges of the court, rather by one judge or a smaller panel of judges. Hence, it is the power of judicial review for a law to be approved and distributed to a member to write their opinions about it. Afterwards, the Chief Justice signs this decision. If any member of the court did not involve from the decision or resolution, the person must state or to provide their reason. Section 14. No decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based. No petition for review or motion for reconsideration of a decision of a court shall be refused, due course, or denied without stating the legal basis thereof. So, in Section 14, there is no decision shall be produced if not all the members in the court would express clearly the facts of the law on which it is based. Hence, there is no review for reconsideration if the decision is denied because of insufficient basis.
So, Article 8, Section 15, all cases of matter filed after the effectivity of this Constitution must be decided or resolved within 24 months from the date reduced by the Supreme Court, and unless reduced by the Supreme Court, the 12 months for all lower collegiate court, and the 3 months for all other lower court. Number 2, a case or a matter shall be deemed submitted for decision or resolution upon the filing of the last pleading brief or memorandum required by the rules of the court or by the court itself. Number 3. Upon the expiration of the corresponding period, a certification to this effect signed by the Chief Justice or the presiding judge shall forthwith be issued, and copy thereof attached to the record of the case or matter and served upon the parties. The certification shall weigh a decision or resolution has not been rendered or issued within said period. So, my explanation is about the period of deciding or resolution or resolving cases. The court shall decide or resolve all the cases within 24 months from the date of submission or resolution. A case shall be deemed submitted for decision or resolution upon the filing of the last pleading brief or memorandum that the court or its rule required. Both the 1987 Constitution has the internal rule state that the 24 months period for deciding on or resolving a case is reckoned from the date of its submission for resolution. The 24-month period does not run immediately upon the filing of a petition before this court, but only when the last pleading brief or memorandum has been submitted. Article 8, Section 15 of the 1987 Constitution provides the period within which court must decide on or resolve the cases or matters brought before it, where no decision or resolution has been rendered or issued upon the expiration of the corresponding period. That's all.
Despite the expiration of the application mandatory period, the court, without prejudice to such responsibility as may have been incurred in consequences thereof, shall decide or resolve the cases or matters submitted thereto for determination without further excuse. My explanation is, even the case's expiration without prejudice to the responsibility shall be resolved and should not be delayed. Section 16. The Supreme Court shall, within 30 days from the opening of each regular session of the Congress, submit to the President and the Congress an annual report of the operation and activities of the judiciary. Therefore, all the cases can be submitted within 30 days, and it will be submitted to the President and to the Congress.